Number 395, Richard Perry Loving et al., appellants, versus Virginia.
On July 11, 1958, at 2 a.m., a Virginia county sheriff entered the home of a couple named Richard and Mildred Loving, forced them out of their bed, and placed them under arrest. What was their crime? Interracial marriage. This is a story of Loving versus Virginia and the barriers broken by this landmark civil rights decision that would set an important precedent for marriage rights in America. But first, we have to go to the roots. Anti-miscegenation laws, a term used to describe the laws that enforced racial segregation at the level of marriage and intimate relationships by criminalizing interracial marriage, and sometimes also sex between members of different races. All anti-miscegenation laws ban the marriage of whites and non-white groups, primarily Black people, but also Native Americans. It also prohibited the issue of marriage licenses. These laws date to the early 18th century, during the colonial period, with Maryland being one of the first colonies to do so. These laws were intended to racially divide the growing lower class in order to prevent an uprising against the aristocratic government. During the antebellum period, most states continued to ban interracial marriage, even despite the rising abolition movement. Following the Civil War, the rise of Black politicians led to the repeal of any anti-miscegenation laws. However, with the Compromise of 1877 and the revival of Southern Democrats, new bans on interracial marriage were passed as part of Jim Crow laws. As of 1967, 16 states, mainly the American South, had still not repealed anti-miscegenation laws that forbid interracial marriages. Mildred and Richard Loving were residents of one such state, Virginia. They had fallen in love and wanted to get married. Mildred Loving was of African American and Native American descent, specifically from the Cherokee tribe. Richard was a white man, and both of their families had deep roots in the area around Central Point, Virginia, where Black people and white people mixed freely with little racial tension, even at the height of the Jim Crow era. Mildred was attending an all-Black school when she first met Richard Loving, whom she initially perceived as arrogant. Quietly, the two eventually fell in love and began dating when Mildred became pregnant at the age of 18, and the couple decided to get married. However, Virginia's Racial Integrity Act of 1924, also known as the Anti-Miscegenation Law, made marriage between whites and non-whites a crime, and barred the Lovings from marrying in their home state. The couple drove north to Washington, D.C. to tie the knot and evade the act, to then return to their home in Caroline County, Virginia.
What happened after you got married?
As Mildred Loving told CBS News correspondent Robert Fearpoint.
The police came after us the 14th of July. We were married a month and a few days.
Mrs. Loving, what has been the worst part about all this for you?
Well, I guess the worst thing that was spending a little time in jail. That's the worst thing.
On January 6, 1956, the Lovings pled guilty of cohabiting as man and wife, and the Lovings were both sentenced to 1 year in prison. They were ordered to leave the state and not return together for 25 years. They followed the orders and paid the court fees and relocated to Washington, D.C. They also had 3 children and occasionally made separate return visits to Virginia to see friends and family. Yet, the two eventually secretly lived in Virginia again, despite the risk of imprisonment. By 1963, the Lovings decided that they have had enough. During this time, the civil rights movement was blossoming into a real change in America. It was a struggle for social justice that took place mainly from the 1950s to the 1960s for Black Americans to get equal rights under law in the United States.
Anyway, they carried us to Bowling Green and locked us up. In January, they had the trial. And they told us to leave the state for 25 years. But the way I understood it, the lawyer said that we could come back to visit, when we wanted to. So that Easter we came back and they got us again.
The Lovings were fed up about the discrimination, so then Mildred wrote to attorney Robert F. Kennedy to ask for his assistance. His office then recommended that she get in touch with the American Civil Liberties Union, or the ACLU. They unsuccessfully aimed to have the case vacated and the original ruling reversed via the judge who saw the conviction. Judge Leon and Basile had said, Almighty God had created the races, white, black, yellow, Malay, and red, and he placed them on separate continents, and before the interference of his arrangement, there'd by no cause for such marriages. The fact that he had separated the races showed that he did not intend for races to mix.
We have 3 children and cannot afford an attorney. We wrote to the Attorney General. He suggested that we get in touch with you for advice. Please help us if you can. Hope to hear from you real soon. Yours truly, Mr. and Mrs. Richard Loving. And it was that simple letter that got us into this not-so-simple case.
Cohen and Hirschkopf took the Lovings case to Virginia Supreme Court of Appeals. When that Virginia court upheld the original ruling, the case of Loving versus Virginia eventually went to the United States Supreme Court with oral arguments held on April 10, 1967.
I would first like to bring the Court's attention there is some discrepancy in the briefs, between us and the Commonwealth especially, as to which laws are in essence. They have particularly said that Section 2058 and 2059 of the Virginia Code are the only things for consideration by this Court. And those 2 sections, of course, are the criminal section, making it a criminal penalty for Negro and white to intermarry in the state of Virginia. 2058 is the evasion section under which this case particularly arose, which makes it a criminal act for people to go outside the state to avoid the laws of Virginia to get married. They themselves would lose their rights for insurance, Social Security, for numerous other things to which they're entitled. So we strongly urge the Court, in considering this, to consider this basic question. May the state proscribe a marriage between such individuals because of their race and their race alone?
The Lovings legal team argued that the state law ran counter to the Equal Protection Clause of the 14th Amendment because it forbade interracial couples to marry solely on the basis of their race. On June 12, 1967, it was victory. The High Court had agreed unanimously in favor of the Lovings, striking down Virginia's law in the U.S. allowing the couple to return home while also ending the ban on interracial marriages in other states.
It's hard to believe. I still don't believe it, I feel free now.
Anti-miscegenation laws have been declared illegal not only in Virginia, but in all 16 states that have held such statutes.
I think that marrying who you want to is a right that no man should have anything to do with. It's a God-given right, I think.
The historic ruling of Loving versus Virginia holds a powerful legacy even 54 years later. According to an analysis of the 2015 census data by the Pew Research Center, 1 in 6 newlyweds in the United States is married to a person of a different race or ethnicity, to where interracial marriages only made up 3% of all marriages in 1967. Opposition to interracial marriage had also decreased. Today, 14% of non-Black adults said that they would be very or somewhat opposed to a relative marrying a Black person, to 63% in the year 1990. The ruling of Loving versus Virginia had also paved the way for Supreme Court's ruling of same-sex marriage laws. The LGBTQ movement molded a lot of its identity based on the civil rights movement.